Because look what I did. Of course, we're on the queen's page. But now, luckily, look at me. I can go back and forth. I didn't know how to do that. And I think whatever I did made it crash. And then when I pulled the internet's back up, it immediately went live. So I was just like sitting here doing nothing. Y'all are going to have to bear with your girl while she tries to figure out life over here. I've been wanting to do this for so long. I've been wanting to do it for so long. Okay, now I need to figure out how I can look at because I want everybody to like engage. I want to have a conversation. I was actually talking to somebody where I was like, I want to be able to get on live and have guests, and then we can be a group speaking of things of interest. So that's my goal at some point. I really hope that that happens. Do y'all like my everybody's got these like incredible setups and I'm like Amazon mic. I don't even care. Who cares? It works just as good. At least I think so. If y'all can't hear me, you're like actually she sounds like she's in a tunnel. I do apologize. But okay. Mhm. Okay. So, what I was going to tell you guys, I was really hoping that I could just do everything on here, and I can't. Okay, so we still have struggle busing going on. I can do it here though. Let's go to my page because that's where the goods are. You know what I mean? Look at us all live and everything. This is so exciting. Of course, I will forever leave this here because I mean, it's just the best. Look, there we are live. Okay, so the last thing I was talking about is this facial tracking, right? I posted yesterday about this Lance Twigs. I zoomed in on it because somebody brought out a great point that it just doesn't look like the pictures that we've seen of him. But see how his face is just kind of ghostly white. So lighting is a big deal in facial tracking. And then they'll have an actual video and then they edit a certain section. So the first thing I noticed was this eye right here is moving separately from this one. And somebody in the comments, which I loved, I wonder if I can pull those up, but somebody in the did y'all see his mouth just there? That's not normal. Allegedly. This is not normal movement. See how his mouth is closed on the sides? So if you go to this post, I kind of have it explained in here about the facial tracking and everything. It's not going to let me do it. That's great. I thought I could just move around in here like I wanted to. If I move around here. Okay, sweet. So we're just going to come over here. Let's just go here. More. All right. Facial tracking is the foundation. Software detects the face and maps dozens and hundreds of landmarks. So this is like pretty much what they're doing in Hollywood, guys, when they're taking a live person and putting all the green dots on them and then they turn them into like a monster or something like that. All of this stuff is very doable. And the thing that I loved everybody's comments. What everybody was talking about is why are we constantly getting this grainy, horrible footage? Well, my person in the know said that that's how you make it look more realistic. Because if they're doing all of this editing and it's really clear, you're going to be able to see it better. So this is just more of the psyop, allegedly, in my opinion. We're just getting constant psyop. So one of the things that was explained in here is, I wonder if this is where it is. Okay, so you can tell because of the mouth, and this is something that you can see in the video too. You don't really see his teeth. It's like this blurred stuff going on inside of his mouth. That's a clue, guys. That's a clue. The blinking rates, I noticed somebody say he only blinked once. I think I maybe saw him blink twice, but who literally does this kind of movement with their eyeballs, just spinning their eyeballs around? Y'all can't even really see me because I'm a little bitty thumbnail over there, but does this kind of movement and they don't blink. Here's what I've noticed that we've seen from everybody on this side of the aisle is every time they talk, they're doing that nervous, constant blinking. Oh, everybody but Lance Twigs, guys. Lance Twigs has zero emotion. Lance Twigs has just this stronger authority core to him. He doesn't need to blink. He's a non-blinker. Lance Twigs doesn't need to blink, but maybe once. while he's looking around with his weird lizard eyes. Another thing that we can focus on about our, just really confident Lance Twigs. Well, why are his eyeballs just solid black and just moving around like a chameleon? He's got the confidence of a god. And look, if y'all want to comment to me, just comment to me on X, I think, where I can see it, because I really am not smart enough to figure all of this out at the same time. I'm going to, though, and I want to be able to read the comments on X. Hold on. Me and X are best friends. Of course, it won't let me see them. I hate it here. I'm just kidding. Okay, so let me bounce around like crazy. Oh, we're back.
All parties, and where we left off is the court took a recess to address,
echoing,
to review the video.
How do I make it stop
I
echoing?
appreciate the patience of the parties as well as everyone in attendance when it comes to constitutional matters and balancing constitutional rights and transparency. This court will take the necessary time to make sure it's given the weight it deserves, and it is deserving of every moment that has been spent. Mr. Novak, turning to you.
I hate that.
And perhaps before you begin.
Okay. I think we're good. Oh, that's why people wear headphones. Can y'all hear it? Okay, look, I can get comments on here. Okay, look, I can get comments on here.
The record on what occurred.
Your Honor, your recitation is accurate. My earlier comments were based on my memory of reviewing this last night. In the recess, I reviewed the feed again, and what you have said today is accurate.
Thank you. Mr. Novak, any?
No, Your Honor,
I'm in a total test trial right now.
Take issue with the court's factual summary.
All right. Turning to you, Mr. Novak.
Thank you, Your Honor. We're going to renew our request to exclude all electronic media coverage from all future proceedings. That was our motion docketed at number 305, and that included video cameras, still photography, and audio. This is the second time that the court's orders concerning the scope of electronic media coverage have been violated. I'm a baseball fan, and I just don't think the court needs to wait for the third strike. 2 strikes is enough. If I may, the alternative remedy, which we think is not wholly adequate, which is why we think it's an alternative and a less desirable alternative, is for this court to both reverse its prior order authorizing electronic media coverage of today's hearing, which we had previously filed an objection to after the court, I would say, preliminarily granted the requests for today. That was sort of the chain of events. And that the court proactively preclude electronic media coverage at the last day of the preliminary hearing, which will be September 1st. Now, I understand that there has not yet been a request for electronic media coverage for September 1st, but there is no doubt that there will be, just as this court previously observed that it wasn't prepared to preclude electronic media coverage at the preliminary hearing because there had not been any requests. There were requests, and those that were timely were all granted. The court denied one request because it was not timely for one particular day. So I guess the way it would be is any request for electronic media coverage of September 1st will be denied because that's the appropriate sanction for what happened yesterday. The fact that the content of the exhibit was previously summarized by the state in certain documents which became public because the state didn't take any actions to seal them beyond the 6-month period. The fact that the contents of the exhibit read in open court is not the issue. The issue is when the court issues an order, everybody must comply with it, and there are reasons for the order. And the reasons, as this court stated, are to protect Mr. Robinson's right to a fair trial. So no doubt that the court balanced those prior ways in which the content of this exhibit had already been disclosed when the court decided that there would not be electronic media coverage. The fact that we have all known of that exhibit, that's a fact that we've all been aware of as we've gone along. So to summarize, and then I will stop because I know we still have a witness here, and of course the court needs to hear from the state and counsel for the media, I suspect, is we would like the court to reconsider its order denying motion 305 and grant it for the balance of all of the proceedings in this matter, or as an alternative, the court prohibit any further electronic media coverage of the preliminary hearing, which includes September 1st.
Thank you, Mr. Novak.
Thank you very much.
Turning to the state and then to the media.
Yes, Your Honor, as to the remedy, we've heard of instances where the media has been able to delay publication of the recordings of the proceedings. We've heard of instances where that has been a short delay of like 30 seconds. I've talked to the media attorney about this, and they do not have the capability to do that right now. My suggestion would be for future proceedings to order the media to look into that capability, and that would be a remedy that perhaps could be used in the future. I think that would be a satisfactory remedy to avoid this type of thing in the future. As to the other remedies requested, we have one witness. The final witness, well, the defense has one witness. That witness is a ATF DNA forensic biologist, and I assume that the exhibits that will be admitted through her will be of that nature. We've already, in fact, admitted the report that she is going to be testifying to. The reports, I should say, that's exhibits 30 and I believe 34. And so I don't think we have, and those have already been published, I don't think we have the same risks or, I'll just say risks with her testimony as we do with some of this other evidence that has already been admitted.
Thank you. To the media.
In a proceeding like this, the parties in the court and the media are working together to learn and to refine their processes. I hear Mr. Novak's remarks about challenges that we've run into in the past. I recall, it hasn't been that long ago, a time when the camera was placed in a location in the courtroom that was causing challenges. The court moved it. When there were challenges with aspects of the court's ruling, the court reiterated those, and those processes improved. We are getting better at this. Media is on board and recognizes the court's obligation and its significant efforts to balance the interests here. In light of the court's ruling, including its recognition that the media operator in this case beat almost all of us to the punch, right? And saw what was happening on the screen and moved away as quickly as they could. We believe that the procedures that the court currently has in place, even if they don't, every moment of every hearing deliver the result that we are intending to deliver. Those processes are working. I don't believe that a further adjustment, much less sanction, much less a revisitation of something that says let's keep every photographer, every camera out of this courtroom for every proceeding. In light of the court's well-reasoned and exhaustive rulings after long briefing on all of this, the court is currently balancing these interests correctly, and we therefore ask the court to allow the parties to recognize that the time we're dedicating this morning represents a reiteration of the importance of these principles. The media and the parties all recognize that, and we'll continue to endeavor at all times to do all that we can to ensure that those are adhered to, and let the parties go forward under the current procedures without further order or sanction by the court.
Thank you. Any further arguments before the court issues its ruling?
No, but thank you for the opportunity.
Thank you. And just updating my notes as I'm intending to issue this ruling right now. I'm just making sure that I'm capturing all the points made in the argument right now.
Testing, testing. Hello, hello.
All right. I'm almost done. I appreciate the party's patience. This issue rises to the level that necessitates great care. And as my practice, I don't like to rush or make snap decisions. And I want to give this the full analysis that it's due. So thank you again for your patience. All right. Court will issue its ruling on the request by defense. The constitutional rights of Mr. Robinson and Ms. Kirk are paramount. Although transparency in judicial proceedings is a fundamental interest, it must be balanced against the constitutional rights of all parties. Having considered the arguments presented by counsel and having reviewed the events that occurred yesterday, the court finds that its order prohibiting the publication or broadcast of Exhibit 16 by the media camera was violated. The court agrees with the defense this constituted a violation of the court's order. Compliance with court orders is essential in all proceedings and is of particular importance given the nature of these proceedings. With respect to defense's request as a sanction that the court reverse its ruling on defense motion 305, motion to exclude cameras, the request is respectfully denied. The analysis underlying the court's prior ruling remains unchanged, and the court adheres to its reasoning and conclusions. With respects to the defense's alternative request as a sanction to prohibit all cameras and electronic equipment from today's proceedings, thereby preventing the electronic capture of the proceedings for those inside and outside of the courtroom, the request is granted in part and denied in part. Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order. The court reserves this sanction as it relates to September 1st. It is not before the court. There has not been a request for electronic media coverage, and the court won't issue a pre-ruling. When it becomes, that request has been filed and all the deadlines which the court has imposed in regards to the MC filing are in place, if motions are filed, the court will entertain motions in brief arguments ahead of the September 1st hearing and address it at that time. This is the ruling of the court. Thank you. Turning to the defense, if you wish, you may call your next witness. When that request has been filed? Yes, Mr. Grenander, and I'll allow all parties, given the ruling of the court, briefly. The MC filing are in place.
If motions are filed,
Wow.
Continue taking
motions,
evidence today.
brief
And
argument.
I'll start my statement, Judge, with something that was very insightful that you said the other day. You mentioned, and I quote, "Sometimes you need to take time to save time," close quote. And so that's my purpose for standing up here this morning. We have spent the better part of a day, a little over 5 hours, I believe, hearing from witnesses that the defense has called at this preliminary hearing. And no doubt the defense is entitled to call witnesses at a preliminary hearing as allowed by the rules. But I think it's important that the court remind all parties about the purpose of this hearing. This is a probable cause hearing, as Your Honor has repeatedly stated. The defense has invoked the term reliability many times. And the court, frankly, has found the evidence that's been admitted, the testimony. As a gatekeeper, the court has found it reliable. It's been presented. The exhibits have been found reliable. So any questions of additional reliability are really questions of credibility of the witness and weighing of the evidence. And that is not really what this court engages in at the probable cause standard. And so this is all couched in the context of a likely forthcoming standing objection that the state may lodge if the testimony is long and drawn out and exceeds the scope of the preliminary hearing, gets into areas of a 702 hearing, possibly even trial. We will lodge this objection, but I wanted to just simply state the authority, Judge, behind our objection if we do make that. As your court is well aware, the magistrate at this stage of the case must view the evidence in the light most favorable to the prosecution. And that's cited to in a number of Utah cases, to include State v. Schmidt. Schmidt continues, "This means that when reasonable inferences from the evidence cut both for and against the state's case, the magistrate lacks the discretion to choose between them and must leave such a determination to the fact finder at trial." A few other cases I would like to refer the court to. State v. Pledger, which is a Utah 1995 Supreme Court case. Speaking of this standard, the court says, "The standard bars the magistrate from requiring the prosecution to address or even eliminate alternative inferences that could be drawn from the evidence in favor of the defense." So even assuming the defense scores points today in calling these witnesses, again, the court cannot really weigh those in favor of the defense. State v. Hester, which is a Utah Court of Appeals case 2000, where there is conflicting evidence, quote, "The magistrate may not sift or weigh the evidence, but must leave those tasks to the fact finder at trial." Of course, we're not at trial yet. State v. Virgin, a Utah 2006 Supreme Court case, indicates that a magistrate may only disregard evidence at a preliminary hearing if it is, quote, "so contradictory, inconsistent, or unbelievable that it is unreasonable to base belief of an element of the prosecution's claim on that evidence." There's a State v. Drozbecki case, which is a Utah Court of Appeals case 2010. Magistrates may only disregard or discredit evidence that is wholly lacking and incapable of creating a reasonable inference regarding a portion of the prosecution's claim, but must leave all the weighing of credible but conflicting evidence to the trier of fact. And finally, State v. Lopez, a Utah 2020 Supreme Court case. Speaking of this probable cause standard at a preliminary hearing, the court said, "Under this low bar, it may be difficult for the defense to overcome a prima facie showing of probable cause. Even an alleged victim's recantations may sometimes be insufficient, given that the magistrate must view all evidence in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution," close quote. Judge, Your Honor has heard 4 days of testimony now. The evidence is overwhelming. It's devastating. And the question needs to be asked, the purpose of continuing with testimony if it's long and drawn out. Of course, the defense has the right to call witnesses, but it needs to be within the context of this preliminary hearing. So again, we may be lodging a standing objection of relevance and exceeding the scope of this hearing. That's my record.
Thank you, Mr. Grunander. Do other parties wish to be heard as it relates to Mr. Grunander's statement? To the defense?
I'm not sure what was being requested by Mr. Grunlander. As I indicated to the court during the testimony of the last witness, we had discussion with the state prior to the start. We had a scheduled date for the court to rule on objections. And the purpose of that hearing was so that we wouldn't have to fly witnesses out from the East Coast if there was going to be a stand objection. Prior to that hearing taking place, the state contacted us after they had participated in interviews of Ms. Oliver and the other experts, and indicated to us, and we indicated to the court, that there was going to be no standing objection to the testimony of these witnesses. So if he's lodging a standing objection now, I think he's waived it, or he should be stopped from asserting it, given the circumstances. I didn't hear that he was asserting that, and I intend to keep this next witness focused on the issue that I think is relevant, which is the state presented DNA reports through a non-expert. They selectively read into the record a portion of those reports, which left an extremely misleading impression of the significance of that evidence. So I have the author of the report here, and I'm going to hopefully educate the court on what the limitations are of the report, and that's it. I hope to be done with the witness by noon, direct and cross, and that will be the end of it.
All right, thank you, Mr. Burt. And before I have you call the witness, just want to make sure that the media had well, I'm not sure if the media needs to be heard on Mr. Grunander's response. No, Your Honor. All right, thank you. All right, Mr. Burt, you may call your next witness.
Thank you. Call Ms. Oliver.
Ms. Oliver, if you'd like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, ma'am, you may be seated. And there's a water bottle to your left if you wish. Now, after you're seated, if you wouldn't mind adjusting that microphone, bringing it close to you to pick up your testimony from today. Mr. Burt, your witness.
Thank you. Could you tell us your name, please?
Caitlin Oliver, Oliver.
And Ms. Oliver, could you bring that mic a little bit closer, so I want to make sure your voice is projected. Thank you. What do you do for a living?
I work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives as a DNA section chief.
And how long have you held that position?
I've been a section chief since January, and I've worked with the ATF for about 9 years. Prior to that, I was a forensic biologist.
And where were you a forensic biologist before you started to work for the ATF?
Prior to the ATF, I worked for Jefferson Parish Sheriff's Office in New Orleans, Louisiana, as a DNA analyst and a DNA quality manager.
Back in September of 2025, what were your duties and responsibilities?
I was a forensic biologist.
And do you recall that around September 11th, you received a request to do some DNA work at the request of the state of Utah?
Yes.
Could we display State's Exhibit 30, which is in evidence? instance, the next sample down, 1.2, where the state read paragraph D, admitted paragraph F, you state in F, based on this calculation, there is evidentiary support for the inclusion of Tyler Robinson, correct? As a possible contributor.
Correct.
Mr. Burt, I just want to interrupt.
Sure.
I was made aware of a question about the media as it reflects this order. So the question was whether audio could be transmitted, and my ruling covered the video display of any exhibits. And so I just want to make sure that's the understanding of all the parties, that the audio of your portion discussing evidence is that you understand that that's going to be captured by the camera and displayed, but not any exhibits displayed. Is that your understanding?
That is my understanding of the court's ruling, yes.
And to the state?
Yes.
And to the media?
Yes, Your Honor, there might be concern about the actual monitors at council table and podium. Any clarification on that?
Well, that's why I give my notation at the beginning of the morning that the parties are responsible to monitor their monitors. And that's there because they're entitled to view it, but they're responsible to ensure that the monitors, as the camera is picking up the courtroom, it's directed not to focus on the monitors, but inevitable capture may occur, and that's why that instruction is given.
Your Honor, Jeff Nyman, on behalf of the representative, we cannot see the court from where we're sitting, so I don't know if there's a way for us to view the monitor.
I don't understand what you're saying.
It's not being published on this.
It's not being published on the monitor to the court's right.
Right, the order of the court based as a sanction is no exhibits will be displayed.
In the courtroom entirety?
As it stands right now, yes, that's correct.
Well,
Okay, please approach the lectern.
Your Honor, it's just hard for the victim's family to be able to follow the evidence if everyone but the victim's family is able to view the exhibits here in court.
Thank you, I appreciate your concern. This monitor is not on either, so it's only the attorneys. The attorneys have a right to view what exhibits are being displayed, to make their motions, objections, and to see it. It is the court's discretion on what's displayed in the courtroom for publication, and the court issued a sanction given the events of yesterday, and that's the court's ruling.
Your Honor, I just asked the court to consider the victim has the right to be present, obviously, at the hearing, and the presence without being able to see the exhibits, again, it's our position, is not meaningful.
Thank you, I appreciate your concerns. Mr. Burke.
Could you redisplay Exhibit 30, please? And again, while he's doing that, that same conclusion where you include the language, go back to that page, please, 5. Use the term, there is evidentiary support and possible contributor. I want to focus your attention on the words evidentiary support. We've had a prior witness testify that, from the FBI, testified that they use a scale and they characterize the support along the lines of strong. Are you familiar with that type of a scale?
Yes.
Does your agency employ that scale?
We can come to 5 conclusions at our agency, so there can either be exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion.
And I take it from what you just said, you don't use these qualifiers strongly. The word strongly include things of that nature.
Yes, we don't use a verbal scale at our laboratory.
Is that a scientific phrase when you talk about instead of saying that there's support for an inclusion, you instead say there is strong support for the conclusion?
So our laboratory doesn't use a verbal scale due to the fact that they add subjective words to the front of this word support. It is our stance that the likelihood ratio statistic, the number stands on its own. So we report the likelihood ratio and either support for inclusion or support for exclusion.
Thank you. Would you go to page 8 of the report? And highlight the very top of the first 2 sentences. You included this language in your report, correct?
Correct.
And in fact, you included this language in all 3 of your reports, referring to the conclusions conform with the relevant Department of Justice policy on uniform language.
That's correct.
Right. And why do you include that language in all 3 of your reports?
It's standard language for our reports. Our reports adhere to the DOJ Ultra statement.
Okay. And could you go now to Exhibit Oliver 4 for the witness only? Not admitted yet. Are you familiar with this document, the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examination using probabilistic genotyping systems?
Yes, I am.
Right. And would you go to page 4 of that document, please? And the court has heard some prior testimony about this Department of Justice directive. What is ATF's, what is your understanding of what the qualifications and limitations are that are required by this policy of the Department of Justice? What are you not supposed to be saying in connection with the reports that you wrote in this case?
There's a few things that the Ultra document states. First, it states if you use a verbal scale, which we do not, then you need to use the one dictated in the document. This is in an effort to unify the language coming out of DOJ laboratories. It also says that we cannot state that our evidence is infallible, nor can we state that there is a inconclusive result.
Shall not state that it's infallible or have a 0 error rate, correct?
Correct.
It also states, does it not, that you shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample.
Correct.
And are your reports in conformity with that? You're not stating or implying that anything you did here is asserting an absolute identification of someone as the source of any of the evidence that you examined, correct?
Correct. With forensic evidence, it's impossible to state with 100% certainty anything. That's why we report a likelihood ratio, to speak to that uncertainty with a statistic.
All right, and would you go to the next page of that document? This policy requires that you not state or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty. You didn't do that in any of your reports, correct?
Correct.
You're not asserting anything with respect to any reasonable degree of scientific certainty,
Correct.
correct? Now, when, you can take that down. When did you first receive the assignment in this case?
I would have to refer to my case record to know the exact date.
Do you have those in front of you?
I do not.
Okay, let me pull up Oliver 3 for the witness only. And go to the third page. Does that third page help refresh your memory on when you may have received this case?
Yes, on September 12th, 2025.
Okay. Is that when you first started doing work on the case, do you think?
Yes, it is.
Now, prior to doing work on the case, did you receive permission from someone to consume any samples in the case?
Yes, I did.
And could you go to page 15 of those case notes, please? Again, for the witness only. Do you recognize this email?
Yes, I do.
And can you tell me what the email is and what information it conveyed to you in connection with your examination?
Yeah, so it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent. We request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So this email is us receiving permission to consume the samples and move forward with testing.
Now, does your policy have, does your lab have a policy for preserving samples for independent testing by the defense?
Where possible, we will not consume samples where it's possible.
And that policy is a longstanding one, not only in your lab, but pretty much everywhere in forensic DNA analysis, right?
That's correct.
Goes back to 1996, does it not, when the 157, which has been admitted. The elimination samples that you requested in connection with item C's from Mr. Robinson's apartment were from Amber Robinson, Matthew Robinson, and Lance Twigs, correct?
Correct,
And that's because you had information that those people were associated with the house.
correct.
And when you tested or compared, first of all, you determined their DNA types, right?
Correct,
Then you compared their types to what you found on the evidence.
correct.
And for a certain number of those samples, you found the presence of DNA of your elimination samples, not because they were suspects, but because they were associated with the premises, right?
There was support for inclusion of some of these individuals, yes.
Okay, and if you could scroll down to page 4, which is the table, I just want to review briefly with you. For instance, item number 1.4, which was a swab from the rifle. You used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I would say there was support for inclusion of Matthew Robinson on the sample obtained from the swabs of the bolts of the rifle.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct. And there
Again,
would-
not because he's a suspect, but because he's associated with that premise.
Correct, and there would have been a likelihood ratio statistic calculated and to go along with that.
Okay, could you go to the next page? Similarly, with respect to 1.6, you found, again, Matthew Robinson on swap number 1.6, or a profile that indicated he was a possible contributor.
There was support for inclusion of Matthew Robinson.
Okay. And next page, actually go page to page 7. You found support for inclusion of Lance Twigs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twigs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twigs's DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
And similarly, you found profiles to suggest support for inclusion of Mr. Twigs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area I want to ask you about is, you're familiar with something called NGS?
Yes.
What is NGS?
NGS stands for Next Generation Sequencing. It's a DNA technique that sequences your DNA, so it looks at the individual sequence of your DNA.
And is it true that in your field, that whole area of NGS is something that's at the forefront of everybody's attention? For instance, when you go to seminars and you look at the presentations, there's a lot of talk about NGS, right?
That's correct. Yes, it's a newer technique.
And is it being developed by ATF as a technique that's going to be used or has been used?
Not at this time, no.
And is there plans to do that?
Not at this time, no.
Okay. Do you know if other labs have implemented it?
I believe there may be some laboratories in the United States that have it in use, but I wouldn't have direct knowledge of that.
Now, you used a program in this case called STR Mix, correct?
Correct.
And that's sold by a company in New Zealand, that software?
Correct.
Have they developed another program called STR Mix NGS?
I'm not aware of NGS software.
Could you go to 156, Oliver 156? Let me know when you're there. Are you aware that STR, the developers are selling a product called STR Mix NGS?
I was not aware, no.
Okay. Now, sequencing analysis is different than what you did in this case, correct?
Correct.
And how so?
As I said, sequencing is looking at the individual sequence, the individual bases that make up your DNA, as opposed to the testing that I'm performing, which is looking at length variations. So STR testing, which is the testing I perform, looks at areas of the DNA that are known to be highly variable between individuals, and there are areas where the DNA sequence repeats itself over and over again. And depending on who you are as an individual, you may have a different number of repeats present at that location. So the testing we're performing is looking at those length variations. There's a distinction between, say, if you have 10 repeats versus 12 repeats.
But you're not looking within those lengths to see what the sequence of the DNA is.
Correct.
And that's what this new technology is designed to look at.
Correct.
And the reason it's designed to look at that is because it's been found that there are DNA areas that are different in sequence, even though they're the same length. Is that true?
I think the reason for developing NGS software is to add another tool to a forensic biologist tool belt.
Okay. Now, could you go to 154, please, for the witness only? You're familiar with this chart?
Yes.
Okay, this lists all the alleles that you found for all the testing in your 3 analysis, correct?
No, it looks like,
No, you were right, 154. Yeah, this is one, what's the exhibit on this? Okay. You're familiar with this chart, right?
I reviewed the first page of this chart. I have
Sure.
not reviewed the entire
Go to
thing.
the first page. This lists the alleles that you found, correct?
For the known samples, yes.
Okay, now go to the second page. And is it true that for the alleles of interest in this case, one of the alleles of interest is at the D3 location, allele 17?
One of the locations that we look at on the DNA strand is called D3. That's a location, yes.
Right, and in this case, the 17 allele is important because Mr. Robinson had a 17 allele, correct?
Correct,
And some of the evidence had a 17 allele
correct,
at that location.
correct.
So as I understand the way you do this, you look and compare whether those are the same number, basically.
I wouldn't state that's how we do our comparison, so it's not just number matching. We're using STR Mix, the STAR Mix software, in order to perform an analysis of the software that looks at the possibilities for a DNA profile and make comparison to the knowns that way. We aren't using a chart and just doing number matching.
Yeah, and I wasn't suggesting you did, but you're looking at the alleles and measuring the peaks, and it's a fairly sophisticated process, correct?
Correct,
But the bottom line is you're comparing alleles one against another.
correct,
So if a person is a 17-17 and the evidence sample is a 17-17, you're looking at that comparison.
correct,
And again, measuring only length.
correct.
But it's true, is it not, that researchers have found at that particular allele, the D317 allele, that there are actually 3 different 17s. 17A, 17B, 17C.
Yeah, so there's something known as isoalleles. What that is you may have, in this case, a 17 allele, but the sequence within that 17 allele is different. So two people may have a 17, but they may have a different sequence within their 17 allele.
And it's been found that there is a 17A, a 17B, and a 17C, correct?
Objection, relevance to the probable cause hearing. At this point, I think we've once again gone beyond probable cause, and based on Mr. Grunlander's argument, I would invoke his argument here in the case law that he referenced, and I object to this question.
Let me withdraw the question, reframe it, and move beyond it.
All right, so I'll sustain the objection. It will be reframed, and we'll go from there.
It's true, is it not, that at least 1, 2, 3, 5 of the locations of interest in this case, researchers have found that the alleles that you were looking at, these isoalleles, have different sequences but the same length.
Objection, relevance. The witness has testified she does not do sequencing analysis here, and that's what the question is asking, is about sequencing analysis.
Counsel?
The point, though, is that her testing cannot distinguish between these isoalleles, and therefore it goes to the weight of the comparisons.
But if she didn't do that,
Yeah, that's the point, is that she didn't do it, and therefore she's not in a position to draw conclusions.
Mr. McBride?
That proffer is inaccurate, that she's not able to draw conclusions because she did not do NGS or sequencing analysis. She has testified that her lab and the analysis she did here is not sequencing analysis, it's something different. Whether or not she could do sequencing analysis is irrelevant to the analysis that she did do. If Mr. Burt wants to call an expert to say sequencing analysis is better or something like that, that's fine. But this expert does not do sequencing analysis. Therefore, the line of questioning that goes into sequencing analysis is irrelevant to her testimony.
Let me see if I could lay a further foundation.
All right, so I'm going to sustain the objection.
Sure.
And the question may be re-asked if counsel chooses.
When you do your analysis using length only, do you go by the rule that if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and reference sample is usually declared a non-match, regardless of how many other loci match?
No, it's not quite that simple. What you're speaking of is an exclusion, is that correct?
Yeah, right.
So it's possible for DNA evidence we spoke about, it's possible that DNA evidence be degraded. In a case like that, there may be the potential that some of the profile has what we call dropped out. So it's not present. In that case, we wouldn't expect necessarily to have a inclusion or exclusion at that location because there's no information present there. So it's not quite as simple as is every allele in this chart present in the evidence. There's more to it than that.
If you had a difference in sequence between a known and a question across many loci, would you exclude the person?
It depends.
Again, objection, Your Honor. We're going back into sequencing, which is not the analysis that was done in this case.
Mr. Burt?
Again, Your Honor, if there could be an exclusion based on this and the testing was not done, I think that is relevant.
But as it relates to this witness and her firsthand knowledge, I'm not seeing that tie-in as it relates to her.
All right, let me move on then.
So I'll sustain the objection.
Now, you said that all the samples you looked at in that one report were mixtures, correct?
Correct.
And the number you get in the likelihood ratio depends on how many contributors you estimate, right? The number is going to vary if you say I think it's a mixture of 2 people versus I think it's a mixture of 5 people.
It's not necessarily the number of contributors. The likelihood ratio speaks to the weight of the evidence. And so it's comparing known individuals to the unknown sample. It could be a low number and be a single source sample. It could be a high number and be a 4-person mixture. It's not necessarily directly correlated with the number of contributors.
Let me ask you if you agree with this. This is from the NIST mixture study. An likelihood ratio numeric value is not a measurement of a physical quantity. Do you agree with that?
Correct.
Rather, it is a ratio of probabilities in the opinion of the expert assessing the likelihood ratio and is dependent on the specific propositions used to formulate it and also on the individual making the assessment.
Correct. Yes, I agree.
And does the final likelihood ratio depend on the number of contributors you assume?
No, it does not.
It has no effect whatsoever?
It can have an effect. It's possible. It's possible multiple other factors could contribute to the likelihood ratio.
Is it somehow difficult to figure out how many contributors there are in a sample?
I guess I would say that I use my, my training, education, and experience in order to determine the number of contributors present in a profile.
Well, I noticed throughout your report, you used the phrase, for instance, with regard to the 1.2 sample, the profile consistent with at least five contributors, at least one of which is male. And for 1.1, you say, the profile is consistent with at least 4 contributors. I assume by the word at least, you're signaling that it could be more.
Correct.
And as the number of people to a mixture increases, the difficulty in sorting out that mixture increases as well, correct?
Correct.
I noticed in your standard operating procedure, there's some guidance on interpreting 3-person mixtures. Familiar with that, right?
Yes.
And it says, and correct me if I'm wrong, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures, based solely on number of alleles present.
It's possible for them to present, yes.
Well, it doesn't say it's possible. It says, for example, approximately, in all cases, assuming a mixture is a result of the combination of 3 people must be done with caution. For example, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures, based solely on number of alleles present.
You said you're referencing my SOP?
Yes,
Is it possible for me to take a look at it?
sure.
Your Honor, I'm going to object at this point. The point that defense counsel is getting at is made in the last answer, which is that the difficulty of sorting out mixtures increases as the number of contributors increases. That's all understood, but that has nothing to do with the probable cause determination. Even if it's difficult, the inferences and the evidence is weighed in favor of the state. The court cannot weigh the difficulty in determining this evidence. Is it fair for a trier of fact at a jury? Sure it is. But we're now getting into weight issues that are relevant for a jury but not for this court.
Well, he's implying this is going to be an extended discussion. I have one question which he wants to look at her manual to make sure it's in there. So, and then I'm done.
All right, I'll allow this question, so I'll
Thank you.
overrule the objection. She may review the material and
So could you bring
question
up
can be rephrased.
one, exhibit Oliver 148? This is your SOP document, correct?
Correct.
And then go to page 83. Did I read that correctly?
Yes,
And so it's true, is it not, that approximately 70% of 4-person mixtures present as 2 or 3-person mixtures?
it's possible.
Thank you. That's all I have.
Thank you. We've been going for a bit, and depending on how much cross, and trying to decide if a break is warranted or if, Mr. McBride, you wish your cross is limited. Again, not trying to say which way you should go, I'm just trying to weigh.
Oh my gosh, I want to take a break so bad.
I will probably be, I will probably be 20 minutes.
All right, let's just.
All right,
let's
we're not
just
taking a break.
Keep going, and then at that point, we can take a break.
Y'all, that was huge. That was low-key huge. 70% is a little more than a probably. She's like, probably. Oh my gosh. Dude, this is blasphemy. That's all I'm going to say. All right, I'm muting.
Good morning.
Morning.
Is your lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary accreditation process where a external third party comes in and audits our laboratory to a set of standards. Specifically, the ATF laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO 17025 for testing laboratories. And additionally, a DNA-specific set of standards put forth by the FBI.
Does the accreditation require that the methodologies you use be validated?
Yes,
The methodologies used in this case have been accepted by courts across the country, correct?
correct.
Does the accreditation require that forensic biologists like yourself satisfy certain qualification standards?
Yes, we're required to perform competency testing prior to participating in casework. And additionally, we participate in twice a year proficiency testing.
And do you satisfy the competency and qualification standards required by accreditation?
Yes,
And at the time you did the testing in this case, did you satisfy those standards?
yes.
Moving to your opinions, where on the firearm did you find evidentiary support for the inclusion of Tyler Robinson?
There were several locations. I'd have to refer to my report.
Okay, would you look at your report, and this is, it looks like report number, or exhibit number 30. If we can pull that up, just for the witness. Thank you, Kimberly. We had it for a minute here, a minute ago. Okay, if we could go to page number 2, please. Will you just list off the areas of that firearm where there was support for, evidentiary support for inclusion of Tyler Robinson?
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle, swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging, the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
We go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory.
And page 4.
The swabs of the protected underside of the receiver of the rifle after disassembly. The swabs of one 30-06 cartridge case. The swabs of one 30-06 cartridge. And the swabs of one 30-06 cartridge.
I want to ask you about a couple of those conclusions. Let's look at page 5, please. And calculation number 3, exhibit 1.3, do you know where that swab was taken from?
I'd have to refer back to page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
1.3 is the swabs of the trigger and trigger guard of the rifle.
All right, going back to page 5. And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
You say at least 1 trillion times more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But the protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6.
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
And same question there. The trillion number, it could be far less than that, but you stop your calculations or the statistics at 1 trillion. Is that right?
Correct.
Let us move to page 7 with regard to statistical analysis calculation number 7. Now, do you remember what 1.3 or 1.13 and 2.1 are?
I'd have to refer back to page 3, I believe.
You could jump to page 3. Thank you, Kimberly.
Page 4, I'm sorry.
Page 4.
The 1.13 is the swabs of the protected underside of the receiver of the rifle after disassembly. And 2.1 is the swabs of one 30-06 cartridge case.
Now, did you do the swabs themselves?
I did not.
And 2.1 is a cartridge case, is that right?
Correct.
And what's the difference between a cartridge case and a cartridge?
So cartridge is unfired, cartridge case has been fired.
Right. Let's jump back to page 7. And what was your conclusion with regard to, well, first of all, why do you group these two together, exhibits 1.13 and 2.1 in your conclusions here?
They were both mixtures of 2 individuals, and they both yielded a likelihood ratio of the same magnitude, so they can be grouped together.
Okay. It's not that they were tested together?
Correct.
It's just that the results were of the same magnitude, so they were reported together, is that right?
Correct.
All right. What was your conclusion as it relates to both of these as to the likelihood ratio?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major contributor and an unknown unrelated individual than if they originated from 2 unknown unrelated individuals.
And did you make a conclusion here as well about the a probability statistic?
Yes, so the probability of an unrelated individual in the population who has not contributed DNA to these samples yielding this level of support, so meaning yielding this likelihood ratio, is less than 1 in a trillion.
Nothing else.
Mr. Vert.
The 1.3 sample is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct, so they were swabbed together, so I wouldn't be able to say where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample, that that was a sample consistent with at least 4 contributors, right?
Correct.
And did what you term the major profile have the largest amount of degradation in that sample?
There was, yes.
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
Correct.
You can't tell us anything about whether, when you say it's at least 4, it could be 5, 6, or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison, and the minor contributor is not suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing, has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yes, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30. Right?
You said Exhibit 1.1?
Yes.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay. And again, with regard to all these samples, no way of knowing when or how the DNA got on those samples, correct?
Correct.
You referenced another statistic in your report, which is the statistic related to paragraph E, I guess.
Correct.
Is it what's called a random match probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio computation, right?
Correct. It's based off the likelihood ratio computation.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute it to any person, can't state it's infallible, can't state there's a 0 error rate, and you can't state that it is a source connected with any one person, correct?
Right. So part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
And address the uncertainty along with the other limitations we talked about.
Correct.
Thank you. That's all I have.
Thank you. Anything further for this witness?
No.
All right. May this witness be excused. All right. Thank you, ma'am. You may step down. Anything further from defense?
No, we have no further witnesses.
All right. Returning to prosecution, anything further?
No, Judge, we have no rebuttal evidence to present at this hearing. The state has no rebuttal evidence to present at this hearing. However, before we break, there is the matter that was discussed yesterday with respect to publishing in the courtroom Exhibit 12.1, so that the victim's family can observe that.
Thank you. All right, do the parties wish to be heard as it relates to this briefly, and then
He's
Alicia's
tired.
ruling and-
Your Honor, I actually just want to make a quick record. We have advised Mr. Robinson of his right to testify at this hearing, and he is choosing to take our advice and not testify.
Is that correct, Mr. Robinson? And I note that he's nodding in the affirmative. Thank you, Ms. Visser. All right, in regards to the outstanding issue about the publication of State's Exhibit 12.1 to the courtroom only, to persons here, any further input from any of the parties before the court issues its ruling?
Your Honor, Jeff and I, on behalf of the victim, my understanding is you ruled yesterday that you were going to play it, that you did grant our request. So I don't know if we...
Thank you.
Judge, I might simply add, given the court's ruling this morning with respect to displaying exhibits, we may want to make a record with the live streaming folks here that it's not going to be published.
Thank you. All right, nothing further from any of the parties? Okay. Just updating some notes. All right. The court wishes to readdress yesterday's ruling in light of this morning's sanction as it relates to Exhibit 16. The court separately addressed that incident and imposed a sanction on the record. Having considered all applicable public access, fair trial, privacy, and victims' rights interests, the court adheres to its prior ruling. The court finds that temporarily limiting live stream to audio only while Exhibit 12.1 is displayed is necessary to prevent the inadvertent publication of the exhibit from being transmitted to outside the courtroom, and no broader and is taking the least restrictive means to accomplish what is being requested. Accordingly, Exhibit 12.1 may be viewed by all persons physically present in the courtroom, including victim representative Ms. Kirk in her capacity as the victim representative. The same in-court viewing rules applies to all parties and courtroom attendees. And that is the ruling of the court. Let's go ahead and proceed to that, to the stage. So could the camera operator let me know when we're switched to an audio only? We are? Okay. All right, and as it's switched to audio only, to the state, now my understanding there's no audio on this surveillance on 12.1, is that correct? All right, so let's go ahead and play that. And I'm going to rule that the
Y'all, somewhere Erica is
this
crying.
also applies to the still photographer. It cannot be captured the screen in any way. I noted video recording, but I intend as well as no still capture of any of the monitors during the publication of 12.1. All right. And to the state, just let me know if you're ready. Let's go ahead and play it now.
This is literally Erica Kirk's worst nightmare because they're using this whole like, oh, Erica and the family have the right to see everything. They don't care. They've already seen it. They don't care. I love this for everyone involved. Because, I mean, honestly, if you're one of the people that's mad about seeing the evidence, what have we seen so far that isn't blurred out, pixelated, or real, allegedly? We haven't seen anything. So what's the point in even looking at any of this stuff? It's like, I'm just so tired of them feeding the world and the internet with their crap. We got AI Lance Twiggs, allegedly. We've got burnt up paper that could or could not be a note that could or could not be written by Lance or Tyler or maybe some random, agent of some sorts, allegedly. We've got video footage of what could or could not be 1 or 2 blurry men, Superman landing off of a roof. Like, I don't even want to see their evidence. I don't want to see any of the prosecution's evidence because it's a lie, 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 lie. Everything's just a lie, in my humble opinion, allegedly. So far, I haven't seen anything that makes sense. I mean, y'all can tell me if I'm wrong, but I don't think I'm wrong. I could be wrong. It's my opinion, right? We're all alleged and in my opinion. But I haven't seen anything from the prosecution that I went, oh, that could change my mind. Not nothing. But it should all be saved for the court case so that they can be like, well, here's what I want to say about any evidence. It better go to the defense so they can actually check the data and the information on every video, picture, whatever it is. When are we going to get the autopsy? Because I really think if we just get the autopsy, that's case closed. I mean, like Barron was saying, it's already case closed because there's no, like, it's got to be without any doubt, no reasonable doubt. Everything just directly points to Tyler. But currently it points to Tyler, Lance, the FBI, the local law enforcement, Turning Point Security, foreign involvement, the White House, Department of War. There's so many planes. So it's like, okay. You could pick any random dude you wanted there and been like, that's Tyler. Oh, no, actually, that could have been it. Oh, no, that could, like, how many of these human patsies did they have? Allegedly, in my opinion. It's out of control what they're trying to shove at us right now. And there is, I have doubt. And I think that doubt should be heard. I just said it. There's so much doubt. Whatever they're watching is taking a very long time. Man, when they were talking about Tyler getting on the stand, I was like, oh my gosh. But yeah, smart him. He is just the silent man in this entire situation. I really wish I had contact with somebody that's in the courtroom because I think, Judge has had enough. You can tell he is exhausted of this whole, we've got to show everything to the family. Meanwhile, like Bert already explained, the family's already seen it. Erica Kirk has already gone on her press tours, told everybody she saw everything. At that point, you can't use the excuse anymore that you've got to show it to the family. No. You want to show it to everybody. Because, I mean, I don't know if y'all saw, what was it? I can't think of his name. Crap. I'm the worst with names. Y'all will learn. I'm a visual. I can tell you every little piece about how they look. Names. not my get down. I wish I could think of it. Anyways, somebody was talking about how they're pretty sure they wanted all of this evidence to get out into the public. So it's like, you know, make the public think what you want. Look, if they start talking, I'll mute myself. Don't worry. But then Tyler's going to, you know, end up in his cell with a note like Epstein. And then it's case closed. And if that happens, that would be horrific. I look at it this way. All of our kids make stupid choices, right? Every kid on the planet makes a dumb choice. Think of yourself when you were 20 years old. Imagine you make this dumb choice because you're just hanging out with the wrong people. You get mixed into this wrong situation, and then you're a part of something that just got way bigger than you ever imagined it would be. And then your life is in danger, and now everything's getting blamed on you. You're going up against foreign involvement, White House, Department of War, Pentagon, FBI, Turning Point USA, huge donors. All, like, how do you defend yourself from that? That's a scary thought. And there is reasonable thought that is what's going on in this case. That is terrifying. All I can ever do is put myself in other people's shoes. And I just literally think, as a mom, I think, like, what if my kid made that stupid mistake and I was going through this crap right now? It's really scary, guys. Allegedly. The whole situation is alleged, of course, but I feel like there's more evidence that I have seen since September 10th that there are way more people involved than this kid. And then your roommate gets exonerated. Like, imagine if Lance was just as involved, but because he's a yap, actually a coward, because he's a coward, he gets exonerated. I'm going to say this too. His video yesterday that got played, that clearly has stuff being manipulated, allegedly. I guess I can't say like clearly and allegedly. His face allegedly looks as if it has been manipulated. We don't know what this kid's going through either, because it's just like the same thing that they're doing with Charlie Kirk. They're using his likeness for their agenda. They could be doing the same thing for Lance Twiggs. That could not have been his voice. That could not have been his face. That could not have been anything about him. But he's in witness protection. He's probably on some gag order, and they're just, the way technology is now, which is not great. Everything we're getting is grainy and horrific. But imagine, I think Lance Twiggs' whole family had to move, and they're all kind of in witness protection, maybe. Like, this is the most insane situation to just get thrusted into because you were playing video games online and you were talking to people on Discord. Literally put yourself in that position. If your kids aren't playing games and they don't understand about all this kind of stuff, you might want to look into it because they all do. This is a possibility that any parent could be in and any kid could be in. Now, the whole, like, I don't even know. Okay. All I know is about being in a straight relationship. But if you're living in an apartment together, do you have separate bedrooms if you're, like, together? Like, I'm even questioning that at this point. Like, they sound like bros. If that voice from Lance Twiggs was even Lance Twiggs, allegedly, in my opinion, right? That's the straightest gay dude I've ever heard. Is that what I'm going to end on right now? Because they're about to talk. That's the straightest gay guy ever. I have a ton of gay friends. They don't talk like that. I've never heard one. I'm Lance Twiggs. What? That was the deepest, unemotional voice I've ever heard. That is not how gay men, I've never heard a gay man talk like that. Ever. There's character and soul in their voice. They're fun. That was a statue robot with a monotone voice. That is not how gay men act. And we're supposed to believe he's a furry?
All right, and that concludes the playing of
We're back. Okay, bye, guys.
Stacy Gibbett 12.1 video transmission may resume. Just let me know when that is live. All right, thank you. Does either party need the benefit of the record?
The state does not, Judge.
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes, Your Honor.
All right, we'll make the recording. Thank you. The court appreciates the professionalism, civility, and respect shown by counsel, the parties, and all persons in attendance throughout these proceedings. As there are no further matters before the court, this proceeding is adjourned until September 1st at 10 a.m. Good afternoon to you all.
All right.
All right, so that's it. Why do I feel like I was expecting more? Hold on, I'm going to re-listen to that really quick. Y'all don't judge me. I got to catch up. All of our kids make stupid choices, right? I guess that, wow, okay, so it's over. You know what I want to happen right now?
In accordance with the court decorum order.
And I apologize. Would you mind putting your names on the record?
Tess Crowley.
Dude, he has so much sass. He's so over all of this. Hold on. Okay. What do we think? See, this is the part. Wow. Okay. So it's over. You know what I want to happen right now? You know what I would love to happen right now is for Candace Owens to do an emergency live. Dude, he has so much sass. He's so over all of this. I would really love that. Okay. Candace. See, this is the part. Candace. Go live. How do we rally? How do we make this happen? Candace. Look, let me go on her page and see if there's any updates. Look, and that's actually, I'm going to change screens. All right, look, we can do this together. Ta-da. Well, that's my page. Not the queens, not the queens. Bear with me for 2 seconds, guys. Let's go. Candace, I want to see an update that says emergency live. Oh, let's read. Let's read, shall we? There's so many. She did this 3 hours ago. We're so late. We're so late. Look, I'm going to take these out. I can't even function with this anymore. I wonder if I'm able to do both. For months, Satanist. Oh gosh, get her, get him, girl. It's fire and brimstone, y'all. Tyler was so motivated by politics and trans ideology, it doesn't even make sense. Like, I don't see it. I don't see it. That he decided to murder Charlie Kirk for trans viewpoints that Tyler held so dearly. He never even expressed them to his boyfriend. What a great point. Until a stunning text message confession after the murder shows us via a picture on Lance's phone, which just happens to be smashed in the very corner that would allow us to verify what time these photos were taken. I love her. This is all very dangerous. The government is playing a very dangerous game here. Yes. Here's the bad part, right? Everybody that's going to fall for this trial is going to be our boomers. They're going to be our Fox News watchers. They're going to be our, the people that have no clue that Turning Point and Erica Kirk just are implicated in so many things because they're not paying attention because they have jobs and they have lives and they have everything like that, right? They're not cool like us, where we've been just watching everything nonstop because we believe in justice. And I have to know things. I have to know all the things, which means I'm constantly plugged in. I have to know. they're going to just watch what they saw out of this trial. They're not going to understand. They're going to be like, oh, well, there's this face. There's no way that's an AI edited video recording. No. Why would they do that? They would never show false AI people, not Turning Point USA. Why would they suggest? That would never happen. Ever. Right, guys? And we're all just sitting here like, dude, they already tried to do this to Charlie. They were already talking about doing this before all this whole time. They think they can just use somebody's likeness and edit it and manipulate it any way they want. But imagine this. What if that's the last time we're ever going to see Lance Twiggs because something happens to Tyler Robinson? You know, he has a heart attack or he commits suicide on himself in prison because that's so hard to do. So then Lance is never going to have to get in front of anybody. We're never going to see his real mannerisms. We're never going to hear his real voice. We're never going to understand any of it because he's just Patsy number 2. So they're like, we're just going to AI edit this, manipulate it a little bit here and there, you know, but we don't like something, we'll take it out. We're editing masters. And we're going to present it to the court in, 2 DPI. Smallest megapixel projection possible in 2026, like we're in when TVs just got released or whatever. It frustrates me that anybody would even give it the time of day, but it's fine. You know, it's not our job to make people understand things. We can only do so much. We can only control ourselves, everyone. Nobody needs to die. We're not doing any more dying. That even goes for Long Live Miss Erica Franzbeck, okay? Now, I want a full report on anybody who sees her cry because she's so mad her last little piece of evidence didn't get broadcasted to the world because that's the whole plan. It was a stage. Everything is a stage. All right. So we're gonna close out. I am so excited that I now learned how to do this. So hopefully we'll be doing it more. I would love to start bringing on guests. If you have any guests that you want to see me chat with, let me know. We're going to be fun, upbeat, and keeping things, in a way that we all don't want to commit suicide on ourselves because it's better to just, you got to laugh so you don't cry. I have some ideas of guests that I'm going to bring on soon. We've been chatting, and I think everybody's going to love it. So make sure you like and follow, run over to YouTube. I have 90 followers, I think, on YouTube. I'm going to start working a lot more on YouTube, guys. This is my first live, and I think it's going to go well. So you guys have a great rest of your day. We're plugging into X for the rest of the day. Okay? See, now I got to figure out how to. Okay.